everyone, this is Emily from Grape Law Firm. We're a global immigration law firm and we primarily focus on US and UK immigration, working with professionals, founders, and employers who imagine beyond borders. Recently, there have been major changes to the H-1B visa process, and understandably, a lot of people are confused or concerned. We've been getting many questions about new fees, changes to the lottery system, and what options still make sense going forward. In this video, I'll explain what has changed, who is affected, how to prepare for the upcoming H-1B lottery, and what alternatives you should consider if H-1B is no longer realistic for you. The H-1B visa is a U.S. work visa that allows American employers to hire foreign professionals in specialty occupations, roles that typically require at least a bachelor's degree in a specific field. The H-1B has long been popular because it allows dual intent, which means H-1B applicants can later on apply to a green card with the intent to permanently remain in the United States. It can be applied to through a job offer, and it has historically been accessible to a wide range of professionals. At the same time, it's always been limited by an annual cap and a lottery system due to the high demand. What's different now is that the H-1B system is no longer just competitive, it's become difficult strategically and financially in a way that we haven't seen before. One of the biggest developments is the introduction of a $100,000 fee tied to consular H-1B filings. The stated goal behind this fee is to discourage abuse and prioritize employers that are making serious long-term commitments. However, in practice, this fee creates a major barrier, especially for startups, smaller companies, and early-stage employers. For many employers, this fee alone makes H-1B sponsorship unrealistic. Another major change is how the H-1B lottery now works. The lottery is no longer purely random. Instead, it's now wage-based. This means higher-paying positions have a better chance of being selected, and lower wage levels are significantly disadvantaged. In practical terms, senior roles now have an edge, while entry-level and junior positions face much lower odds than before. While these updates make the situation appear bleak, it can also be a huge advantage with the right strategy. In 2025, the U.S. Chamber of Commerce challenged the legality of the $100,000 fee. While that challenge was initially denied, in late December 2025, the case has already been appealed to a higher court. Several other lawsuits, including a coalition of 20 states, are simultaneously working through the judicial system, which means that there is still a chance that the fee might be waived. In any case, despite the current ruling, there are 3 critical reasons why eligible candidates should proceed with the lottery registration for an upcoming season. The first is fee timing. It is a common misconception that the $100,000 fee must be paid upfront. In reality, you only pay the standard registration fee to enter the lottery. The $100,000 fee is only triggered after you're selected and your employer moves forward with the formal visa petition. The second is legal volatility. The legal situation is fluid. If a higher court issues an injunction or strikes down the fee, the requirement could be removed at any moment. By entering the lottery now, you lock in your spot so you're ready to benefit if the fee is abolished during the filing window. And finally, the low entry advantage. High fees have discouraged many applicants and employers, leading to a significant drop in total entries. Because there is less competition, those who do enter the lottery may face the highest selection odds in years. Joining the lottery now is a low-risk, high-reward strategy to secure your chance at a visa for a minimal initial cost, while positioning yourself to take advantage of a potentially favorable court ruling that could eliminate the high fee before your final application is due. There is also an important exception to the $100,000 fee that many people are not aware of. If you apply for H-1B through a change of status within the United States, the $100,000 fee does not apply. This is especially relevant for individuals currently in the US on F1 student status, OPT or STEM OPT, or other valid non-immigrant statuses. This means that where you're applying from matters, and timing your strategy correctly can make a very significant financial difference. If you can manage, you should aim for a change of status and avoid the fee entirely. As you can see, if you play your cards right, there are many ways to turn this situation into an advantage. Since the H-1B lottery registration period is approaching, you should start preparing now. To properly set yourself up for success at the upcoming lottery, you should follow 3 key steps. Confirm that your employer is willing and prepared to participate. Review the job title and job duties carefully. Make sure the role clearly qualifies as a specialty occupation. Wage level is also critical. Employers need to understand that how a position is classified and compensated can directly affect lottery outcomes and should prepare accordingly. In essence, a participant's odds can be improved by higher wage levels, clearly defined specialized job roles, and employers working with experienced immigration counsel. That said, even very strong cases are not guaranteed. Preparation improves your chances, but it does not eliminate risk. That is why it's critical to plan beyond H-1B, not just around it. For many people, especially those who cannot do a change of status inside the US or whose employers cannot afford the new H-1B costs, it's important to understand that H-1B is not the only option. One of the strongest and most overlooked alternatives is the O-1 visa. The O-1 visa is a US work visa for individuals who demonstrate extraordinary ability in their field. And I want to pause here because the word extraordinary often scares people away before they've even looked at the criteria. Extraordinary does not mean Nobel Prize winners, celebrities, or world-famous figures. In immigration law, extraordinary ability means that you have distinguished yourself in a field and can show evidence that you are well above the average professional level. The O-1 visa is divided into two main categories. O-1A, which applies to individuals in business, science, technology, education, and athletics, and O-1B, which applies to individuals in the arts, film, and television industries. If you're a founder, executive, engineer, consultant, researcher, or someone working in a specialized professional field, you are most likely looking at the O-1A category. If your work is creative fields such as design, media, film, music, or entertainment, the O-1B category may apply to you. To qualify for an O-1 visa, you do not need to meet every possible criterion. Instead, the law lists multiple criteria, and you generally need to meet any three of them. These can include things like media coverage related to your work, playing a critical role in a distinguished organization, high salary compared to others in your field, judging the work of others, or original contributions to your industry. What's important to understand is that many professionals already meet these criteria without realizing it. People often normalize their achievements and assume what they've done is standard, when in fact it's exactly what the immigration law looks for an O-1 case. Unlike H-1B, the O-1 visa has no lottery, no annual cap, and no $100 fee. It's entirely merit-based and focuses on your individual background and accomplishments. This makes the O-1 visa a particularly strong option for people who are being priced out of the H-1B system, are affected by the wage-based lottery changes, or want more control over their immigration journey. The key takeaway here is that the term extraordinary ability should not discourage you. The O-1 visa is not about perfection or fame. It's about how your experience and achievements are presented and documented. For many professionals today, especially in light of the recent H-1B changes, the O-1 visa is not a backup plan. It's often the better plan. To wrap up, the H-1B visa system is changing rapidly. It's becoming more expensive, more selective, and more complex. Now, more than ever, immigration success depends on early planning and smart strategy. If you're trying to decide whether H-1B makes sense for you or whether another option would be stronger, Grape Law Firm would be happy to help you evaluate your situation. You can reach us at info@grapelaw.com. And for more clear, up-to-date guidance on US and UK immigration, subscribe to our channel and hit that notification bell. We'll see you in our next video.